Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, I told you I'd be getting emails and stuff like that, but I don't really care. When you start talking political, you get all these people that are unhappy and expressing political views. But hey, you know what? Don't really care. Move on. All right, and end of story. I just take your emails when you start yelling at me and blah, blah, blah. You know what I do with those? I put them in the shredder. At any rate, let's talk about something else today. Let's talk about the Fair Scheduling Act. Now, this is for California out there for my listeners, so just to let you know how insane that we are here in California with our legislators who have nothing else better to do than to turn around and think of every possible way that we can do and give more benefit to employees. Now look, in the past I've actually given employees suggestions and things of that nature, so I've done that. So don't jam me up that I'm 100% all employer, because I'm not all employer. I believe that every work environment should have a good work environment, and employers need to train their managers to make sure that they're providing a healthy and wholesome work environment. So let me just make that clear. But now here comes another law that the Senate Labor Committee is passing. Now, already keep in mind that California's already raised minimum wage and expanded its family leave rights. Now, for those of you who don't know about that one, let me just take a moment. California, in San Francisco, has passed where, in fact, the employees, when they go out on a leave of absence under the FMLA, or the California Family Rights Act, are now able to collect basically 100% of their salary while they're out. 55% paid paid to them through the EDD, called Family Temporary Disability Insurance, and now they have the expectation that the employer is going to pay the other 45%. Now, you look at that and say, okay, this is getting to be ridiculous, but of course it is. Now, in addition to that, is what they have on the bill right now, is that they are seeking to pass in California that in order to qualify for FMLA as an employer, to be a qualified FMLA employer, you got to have, before it was 50 or more employees. They're talking about dropping that number down to 5 employees. Do you have any idea how that's going to just kill employers, the small employer? You got to be kidding me. How in the world is a small employer who has 5 employees, let's just say 2 of them go out on the FMLA, and now they got to pay 45% of their wages while they're gone for 6 weeks? Oh yeah, that payment's only for 6 weeks, by the way. But they got to pay half of that person's salary while they're gone for 6 weeks, when in fact they probably need to hire somebody else, possibly on a temporary basis. At any rate, don't get me to talk anymore about this, because then I get kind of sensitive and you'll tell me I'm getting too political again. But anyway, they got another bill now that's expanding more employee rights, called SB 878. Okay, now this bill is designed to require California grocery, retail, and restaurant employers. So this is very specific this time, but retail definitely reaches out to automobile dealerships as an example. All right, because that's all retail. So California grocery, retail, and restaurant employers to provide employees advance notice of their work schedules. Okay, I got no issue with that. People should know their work schedules in advance. All right, but listen, and I'm going to repeat that: to provide employees advance notice of their work schedule and to pay its employees, hold on to yourselves, modification pay for any unilateral changes that the employer makes to the schedule thereafter. Now listen to that. Is what they're saying is that here's your schedule, and if an employer has to change the schedule, they got to pay them a modification pay for changing the schedule? You got to be kidding me. SB 878 in its current form requires covered employers the ones I just told you about, grocery, retail, and restaurants, to provide all non-exempt employees with their work schedule, setting forth all hours worked at least 7 calendar days prior to the first shift of the schedule. Now, in all honesty, I don't think that's unreasonable, because I think people should know in advance what their schedule is. And 7 days is not an unreasonable amount of time. Now, if the employer subsequently cancels or moves the shifts to another date or time, or subsequently requires the employee to work a shift not provided on the schedule, the employer must pay this employee this modification pay on top of his or her regular pay and any applicable overtime. Now, once again, I don't want to be political, okay? But you got to look at this and wonder, what in the hell is going on in Sacramento with some of this stuff? They are putting employers in a situation where employers don't want to do business in California with all this overregulation. It's ridiculous. Now, let me just go and expound on this a little bit more about this bill. If the change occurs more than 24 hours prior to the shift, but less than 7 calendar days, the employee receives an additional hour of pay. So that's what the modification pay is. They receive an additional hour of pay at his or her regular rate. If the change occurs in less than 24 hours prior to the commencement of the shift, the employee receives the modification pay that is at least equal to half of that shift's hours. Half of that shift's hours? When the shift could be an 8-hour shift? So 4 hours of modification pay, but in no event less than 2 hours and no greater than 4 hours. Are you freaking kidding me? You're going to pay an employee because you have to change their shift? You know, what about emergencies as an example? All of a sudden there's an influx in business. You got to turn around and pay this individual 4 hours of pay because you changed their schedule? Listen, Sacramento legislators, I don't know if you can hear me or not, you're killing employers. Now, admittedly, there are certain exemptions to modification pay that includes, here we go, the standard acts of God. All right? So I'm glad that they remember that. Illness or vacation of another employee where the employee did not provide 7 days notice of said illness. Now, how in the hell does a person give you 7 days notice that he's going to be ill? Oh, I just want to let you know, I'm going to be ill next Wednesday? Are you kidding me? That's ridiculous. Just to let you know, Mr. Employer, I'm going to be ill next Saturday. Now, I'll tell you what normally happens. They're ill on Monday. They're ill on Friday. But you know what? They don't give you notice of that. They want 3 days off. You think they're going to say, oh, by the way, don't worry about me. I won't be in on Monday because I'm going to be sick. Give me a break. All right? And the other thing is that another exemption is where utilities are unable to provide water, gas, or electricity, okay? So that causes the modification. So that's what they're saying. If there's a gas issue, water issue, electricity issue, that's a little bit different. In addition, the modification pay is not required where the employer requires the employee to work overtime beyond the scheduled shift. Now, you hear about employers talking about moving out of California. They're moving to Texas. They're moving to Nevada. You wonder why? We need our California legislators to understand, that you're killing businesses. And the only thing I can think of is that the people that go up there to Sacramento and they call themselves their legislators, they've never owned a company. I can't explain it any other way. Because if they ever owned a company, there's no way that with some of this they would actually be passing these kind of laws. You're strangling employers. You're telling me that if I got to change somebody's schedule within 7 days, I got to pay them this modification pay? And if it's less than 24 hours, I got to pay them half the shift? You got to be kidding. How many restaurants are out there? How many employees are out there? I'll tell you this. After this goes in, I want to know how many of you are going to be eating at a restaurant after this. Because I'm telling you, I would get a food tester if I were you. Because, what you're trying to do to the restaurants as an example, to me, is just absolutely ridiculous. Now, look, retail business is retail business. and there's a lot of retail. I mean, I don't want to say everybody that's in business probably in California has a retail business. The grocery stores already. So who does this not affect? Well, it doesn't affect law offices. It doesn't affect doctors. It doesn't affect, let's see, CPAs. But who else is there? Retail, any product that you're selling, technically. Hell, I think we sell some products with some of our things. So maybe it does. Maybe it does apply to us. So at any rate, look, California, you guys got to be more reasonable. Since I have another couple of minutes left, I want to tell you about a couple of other pending bills as well. The school activities leave. Now look, there's a labor code section out there called 230.8, and that requires employers with 25 or more employees to provide up to 40 hours of leave per year to employees who are the parent, guardian, grandparent of a child enrolled in a licensed daycare facility or in grades K through 12 for the purpose of participating in school activities. Look, I've got grandchildren. I get it. I understand it. I had kids, and I went to their school activities. I get it. So I don't have an issue with this. But this new bill, guess what it also expects? This new bill, if it gets passed, you got to now pay 24 hours of pay out of the 40 hours. Now, they already passed a law in California last year with the 3 days of sick pay. Now you're going to turn around and give them 24 hours of pay when they go to their son's school play or their sons or daughters, they got to go meet with the teacher. Employers have to pay for that? Look, my producer's waving me down right at the moment because my time is up. And I will tell you, anybody who wants to talk about this further, get in touch with me because I think that this is ridiculous. And if any of you legislators are listening to this, I would appreciate a phone call. Oh yeah, I'll wait for that call. All right, with that last comment, it's time to close out this segment. But let me remind you that you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday. Give us a call between 9:45 and 10:15, 10:30, and you'll reach us. Just call 855-4J-POTS, or you can call 855-457-6887. Or email us at Listen Up with James William at JamesWilliamPottsLLC.com. Okay, I'm Jim Potts. I appreciate you listening. I'll continue to fight the fight. Catch you next time.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@JamesWilliamPottsLLC.com. Until next time, make it a great week.